my lord, ladies, my lords. Yes, before lunch I was looking at the fact that the courts below had found correctly that the fiscal measures would be less of an obstacle to freedom of movement, and that the respondents failed to, although they suggested otherwise, had no evidence to counter anything said. But one of the main issues in this case, which has already been alluded to in discussions with my Lord Reid, is that you'll only be able to work out what the least restrictive alternative test is if you know what it is they're supposed to be getting at, what they're aiming for. So I think it's worth just reminding ourselves on the issue of the aim. And so in that regard then, look first of all at the Advocate General's opinion, which is at tab 13, paragraphs 115 to 117. So that's first of all page 1888. Yeah. And it's paragraphs 115 down to 118, and it's worth looking at that properly, because it is actually quite important. So I'll just go through that.
It's supposed to be properly then.
Well, on my part, it was
Which bundle will I find this in?
I was telling myself to look at it properly. Sorry, it's tab 13, and that's in the second volume of the Authorities, Part B.
You can also get into core volume 2 if you want.
I'm referring to the report.
Volume 2 at 373.
Thank
Yep.
you.
I've been referring the court to the reported version of the, just for ease.
373. Thank you.
So, as I say, I'm sorry, Lords, I will look at it properly. So first of all, Advocate General is saying it's necessary to identify the objective pursued by the measure in order to determine whether the measure is proportionate to the objective. This is a business of, you'll only know what the result is if you've got the input properly. So focusing on what the legitimate aim is important. The referring court observes the measures at issue were presented in explanatory notes accompanying the draft legislation intended to implement the general and targeted strategies and interventions aimed at the population in general and at harmful drinkers. So that's them referring to the explanatory notes, harmful drinkers and the general population. And he defines what harmful drinkers are. It's over 50 units for men, 35 units for women. However, the referring court adds that a more recent study, that's the BRIA, as it's called, the Regulatory Impact Assessment, states the objective of the measure is to include combating hazardous consumption. So that's not harmful, but drinking over the guidelines of 21 units and 14 units. For men and women respectively. The study concludes the introduction of a minimum price enables the objective of reducing the consumption of alcoholic beverages which are cheap in relation to strength. As it said, hazardous and harmful drinkers are more affected than moderate drinkers in terms of the amount they drink and the amount they spend. But then the referring court notes that when the measures were notified to the Commission, the Advocate General says that they were restricted to the protection of hazardous and harmful drinkers. That actually is not correct, and I'm afraid the Advocate General is getting himself confused, but it's just symptomatic of the fact that there are all these shifting aims. But he goes on, paragraph 117, the ambiguity that emerges from that development in the presentation of the objectives of the measure is not made any clearer by the written observations of the Lord Advocate, since while observing that a measure fixing an MUP is introduced in order to attain the twofold objective of targeting the part of the population whose health is at greatest risk, having a positive effect on the health of the entire population, they recognise that the justification for such a measure is based solely on the first of the objectives. That persistent ambiguity gives the false impression that the objective of reducing the consumption of alcohol in general is deliberately ignored. so that the measure at issue may more readily pass the necessity test when compared with a fiscal measure leading to a general increase in the price of alcoholic beverages. So the Advocate General is saying, rightly, that there is an ambiguity in their approach. The supporting documents refer to the general aim, certainly, and then they talk about targeting either of hazardous or of harmful drinkers. But in fact, in the reference made of this draft measure to the Commission, the Scottish Government referred to the twofold aim of the measure. If we look at page 479, apologies.
Sorry, 791.
4791, my apologies.
4791.
Yes. And this is this is not produced in the bundle. It's on the memory stick only. It's in Appendix Part 2, I think. So this is the notification of the measure to the Commission by the Scottish Government, and we see it at paragraph 9, which is at page 4792, sets out a brief statement of the grounds. And it says, minimum pricing aims to reduce alcohol consumption across the Scottish population to improve public health and attain social benefits in the areas of crime, public services, productivity and the economy. In particular, it aims to target a reduction in consumption of cheaper alcohol products relative to their strength because the evidence shows that this product is more likely to be favoured by hazardous and harmful drinkers, and they are likely to benefit from a reduction in alcohol-related harms. And then they refer to the BRIA. Now, this business of this type of product is likely to be favoured by hazardous and harmful drinkers was done at a time before the Scottish Government and the Sheffield report in which they were basing their views had not identified that hazardous and harmful drinking is associated with affluence rather than poverty. So that statement has to be taken with some qualification in terms of the claim, because we know subsequently that, as I say, hazardous and harmful drinking is a richer man's disease. My Lord Mance asked for the figures on that because it is referred to by the extra division, and if one looks, the extra division refers to the figures at page 396, paragraph 16. But it knows at paragraph 15 at 396, after the passage of the legislation, so after the BRIA that makes the claims, Sheffield University was able to carry out further survey related to incomes and affluence. On the basis of these surveys, furnished certain data. In summary, those in the lowest income quintile in that of consumers in that quintile were classed as harmful. The figures are there. And then in the highest income, it rises. It thus appears that the incidence of harmful and hazardous drinking, indeed the consumption of alcohol generally, increases with affluence. And the court is, in fact, summarising what it saw on a bar chart from the Sheffield authors, which is at 4894. This is a bar chart that sets out consumption distribution by income group. And it starts from the lowest income to the highest income. And it's done like a traffic light in the sense that green is moderate drinking, orange is hazardous, and red is harmful. And we see going across as income increases, the red and the orange increase significantly. So hazardous and harmful drinking associated with affluence. And as I say, that was information which became available to Sheffield after it had made its initial study, after the passage of the legislation and after the BRIA was made.
Was this individual income or household income?
It's an interesting point, lady. I think it would be household income, but again, that's something I'll bottom down on.
So of some interest, isn't it?
Oh, absolutely so, because of course you can have one heavy drinker within the household. Yes, it's based on household income, I'm reminded.
Thank you.
Going on then, as part of this, just what exactly is the aim? In the face of those figures,
Is there any bar for not drinking at all?
yes, that's the
that's
bottom
brilliant.
one. I didn't bother to mention that. And again, it's interesting that the incidence of teetotalism is the poorer you are, the most likely you're not to be drinking, because you can't afford it, presumably. Yes, so abstinence is a...
And is this in the UK generally or in Scotland?
That's in the UK generally. But those are the figures which which first alerted, I think, the court to the fact that the claims about hazardous and harmful drinking being associated with buying cheap alcohol was perhaps not something which the empirical evidence, once that had been factored into your Sheffield model, would immediately be out.
I see that at 398, Vienna House say that the survey data relates to England and Wales. Is that right?
It may be, but the,
Preceding page says how much of the UK's alcohol consumption.
yes, it's. But in any event, it is clear that the figures we have for Scotland bear out the same pattern. I don't think that's ever been disputed of hazardous and harmful drinking being associated with affluence.
Yeah.
It was, in fact, contrary to what the Advocate General thought, it was before the extra division, not before the Commission, that the Lord Advocate sought to disavow the broader aim of general population reduction, although that was an aim which was set out in terms in the BRIA and in the explanatory notes. This was always presented and to the Commission, but in the face, I think, of the evidence about this, they attempted to redefine what the aim was. And we see that at paragraph 46 at page 1851 of the extra division's statements. So paragraph 46, 1851 of the reference by the extra division says this. Mm-hmm. While the materials before the legislature, that's the Scottish Parliament, and the terms of the notification to the EU Commission were expressed in terms embracing general population-wide benefits and the reduction in the consumption of alcohol with consequent general societal benefits, in the proceedings before the referring court, the Scottish ministers accept, so this is another significant acceptance, that those wider perceived benefits cannot be put forward as a justification in terms of Article 36, because those wider benefits could more readily be achieved by fiscal measures, less disruptive of competition than minimum unit pricing. For the purposes of justification under Article 36, the Scottish ministers contend that the only relevant aim of the measure must be seen as limited to the protection of the health of the hazardous and harmful drinker. Now, it is not, as a matter of constitutional law, frankly, for the Lord Advocate to shift on the aim of a measure which has been passed by the legislature. It is not on his say-so as to what the aim of legislation is. It is what was the objective intention of the Parliament in passing it. That's a matter of straightforward constitutional law. Ministers don't say what the law was intended to do. Parliament does. Parliament passed it. And one looks at the relevant information as to what Parliament understood it was doing, and that's to be found in the BRIA, which talks of the general objective, and in the explanatory notes. So, simply put, it is not, as I say, for the Lord Advocate to attempt, and it should not be accepted by the court, that the Lord Advocate can redefine aims in the face of new evidence.
Even if, I mean, I take that point, but even if it weren't right, this would surely come into the balance as a detriment, because it accepts that there is disruption to competition for which there's no justification outside the aim, but as a result of the fulfilment of the aim, the narrow aim of targeting impoverished drinkers.
Yes, at this stage we're not even at the impoverished still, because the impoverished aim comes in before the first division. At this stage we're just at the stage of hazardous and harmful drinkers.
Well, I'm sorry, I meant hazardous and harmful.
But no,
isn't
Lord,
that right? That this demonstrates that there's a detriment to be brought into the overall balance.
Yes. Yeah, I mean, it's a clear acceptance that if you're trying to reduce alcohol consumption by the population as a whole, tax is what does it, because tax covers everyone. So, but as I say, this is an attempt to redefine an aim. That is contrary to the constitutional principles set out, for example, in Wilson against First County Trust. I'll just give the reference to that. That's at tab 34, MS page 2715, and it's the judgment of Lord Nichols at paragraphs 56 and 58 and 67. That's to be found at pages 2739, 2740 and 2742 to 3. That case, which doubtless Lord Sumption will remember particularly, having appeared for the Speaker, was one in which the issue of reference to parliamentary materials was raised, and the House of Lords reaffirmed the cardinal constitutional principle that the will of Parliament is expressed in the wording of the enactments. The wording of the enactment, as understood against such information as was available to the Parliament at the time of its enactment. So, as I say, the attempt was made to redefine the aim, nevertheless, by the Lord Advocate before the extra division. But then when we came before the Court of Justice, we see that they've resiled from that attempt. We look at page 1902 in the decision of the Court of Justice, which is tab 13, authorities in volume 2, and it's paragraph 34. We see there, as regards the objective pursued by the national legislation in the issue, the referring court refers, it's apparent from the explanatory notes that accompanied the draft and the BRIA, that the legislation pursues a twofold objective, that of reducing in a targeted way both the consumption of alcohol by consumers whose consumption is hazardous or harmful, and also generally the population's consumption of alcohol. At the hearing before the court, so this is a matter which was specifically raised by the court, relatively unusually, in oral submissions. They asked questions occasionally, and one of them they asked was, what is this aim? Because there seems to be such a shifting move about it. At the hearing before the court, the Lord Advocate confirmed that twofold objective, which, being aimed at the whole population, includes as targets, albeit only secondarily, drinkers whose consumption of alcohol is moderate. So, the Court of Justice has found that stated to be the aim when it's pushed on the point. It has found, as a matter of fact, that is what the aim, and that accords with the relevant material that was before the legislature. So the attempts of shifting seem to have stopped, one would have hoped. Unfortunately, before the first division, they seem to have started again, and the first division was perhaps led by a renewed ambiguity as to what the aim of the measure really was.
so that it seems from that the primary target are consumers whose consumption is hazardous and harmful. That's what the court
Yes.
is saying. And,
Indeed, because they're the ones hazardous and harmful drinking. Sorry, Lord.
and secondarily, the more moderate consumers are a target in the context of an aim to reduce alcohol consumption overall.
And against a background of the means which has been chosen has been a universal pricing measure. And it's the fact that a universal pricing measure, all alcohol sold in Scotland will have price raised, is the point that if you are going to have a universal pricing measure in which one of your targets is moderate drinkers to reduce overall consumption, then why not tax? We always come back to that, why not tax? And the attempts to answer why not tax shift depending on where or which forum they would apparently appear to be. But luckily, as I say, before this forum, we have agreed in terms precisely the legitimate aim which the Court of Justice identified at paragraph 34. And the wording used there is the wording which has been adopted and agreed to by all parties in the statement of facts and issues. If we then go on to see what the First Division thought the aim was, I think at page 1969, I think. Paragraph 181, the First Division mentions the BRIA, the policy memorandum, painting a picture of minimum prices will target cheap alcohol. The critical feature is it will target harmful and hazardous drinkers, since they are the ones who tend to buy cheap alcohol. As I say, that is questionable. It will have a significant impact on those in the lower quintile of affluence, since unlike richer citizens, they will not be able to trade down to products which are cheaper than they are presently consuming. It is this poorer section of society which is most affected by cheap alcohol in terms of hospital admissions and mortality. That may not be surprising given economic differentials, in particular the comparative levels of housing. The fact that minimum pricing may not to the same extent affect those who are more affluent is of peripheral significance. Why is it these richer people tend not to suffer to the same extent as harmful and hazardous drinkers in the lower quintile of affluence, whose health and life is at the greatest risk? And then paragraph 204, page 1975. Proportionality must involve a balance. The documents, notably RIA, contain a detailed analysis. 50 pence figure will, on the material produced, reduce consumption amongst harmful and hazardous drinkers in that quintile of the population whose health is most affected most by the consumption of cheap alcohol. Actually, the BRIA didn't do that because it didn't have any input on terms of income and affluence. And then paragraph 206 on the same page. About 7 lines up from the bottom, in paragraph 206, page 1975, the First Division, in a sentence beginning minimum pricing. Minimum pricing would attain the stated objective of protecting life and health, particularly of harmful and hazardous drinkers in the lower income quintile gauged by wealth of the population. So the whole aim now is where we've brought in poverty. We've seemed to have ignored completely the general overall aim of reducing population consumption generally. We've lost out on hazardous and harmful drinkers who actually tend to be richer rather than poorer. And we now have a stated objective of protecting harmful and hazardous drinkers in the lower quintile gauged by wealth of the population. But that wasn't the aim which the legislature had in mind, as we know, because it was an overall measure seeking, as the Court of Justice notes, albeit secondarily, to reduce moderate drinking, and as the respondents have accepted, for an overall general measure which seeks to reduce, among other things, moderate drinking of the general population, taxation is the way to go. So, as I say, that is the history of the shifting aims and why it is important that the aim be defined, not by reference to what evidence the Lord Advocate thinks can best now justify it as a part of retrofit, but actually one sticks to the aim which Parliament thought it was doing when passing the legislation and seeing if those aims can be better achieved by measures which are less disruptive of less of obstacles to the free movement of goods and less disruptive of the common market organisation. And that seems to be accepted and established as a matter of fact and agreement. So, one would think, therefore, in the face of that weight of evidence, that when this court, or any court, asks, as it's required to under the test, is it possible to use a combination of fiscal measures, such as varying excise duty, introducing other indirect taxes on alcohol, and banning sales at anything less than tax due, so as to reduce the amount of alcohol consumed by hazardous and harmful drinkers, at least down to the levels sought by the respondents, and also, more generally, to reduce the overall levels of consumption of alcohol by the population as a whole? Well, the only answer to that question is yes, it is possible. And therefore, that is the least restrictive alternative. As we have pointed out repeatedly, this is not an issue, as I think might be presented by the other side, as because it was in the courts below, that if you don't uphold this measure, you're going to let people die in Scotland. It's equivalent to the homicide rate, we're told, and that's what this is trying to stop. Nobody is trying to stop pricing being used in the manner to reduce consumption. It just has to be used in a lawful manner. And the lawful manner is the various excise issues, models which we have set out, and on the respondents' own evidence, excise, even at its crudest, can achieve every one of those aims. The
reasoning you were showing us in the first division, it says essentially focus on the lowest quintile. They're the people who are being hit by or will be protected by a minimum price. And you showed us earlier the statistics which show that in fact it's the highest quintile where there is the greatest percentages of harmful and hazardous drinkers. I mean, doesn't the reasoning of the first division actually contradict that? It's saying, well, these aren't really drinkers who are either exposed to hazard or harming themselves. So where is the statistical basis for the contradiction for saying, forget about the highest quintile?
There is none, and it wasn't presented. The issue was always.
Well, Mr. O'Neill, if one goes to MS 1806 in the opinion of a Lord Ordinary, paragraph 59, Lord Doherty explains that whilst it's correct that there are a greater number of hazardous and harmful drinkers in higher income than in lower income groups, the harmful drinkers in the lowest income quintile consume far more alcohol per head
Yes.
and are the source of much greater health-related and other harm than harmful drinkers in the higher income
Yeah,
quintiles.
that's what
So it's the actual consumption, it's the sheer amount of alcohol that the poor people are drinking. The poor hazardous drinkers are drinking. The sheer amount is much greater.
No.
That's why they're dying.
I think, Lord, I think that's perhaps, and this is the problem with statistics, that some people in the lower quintiles are on average drinking at excessive amounts of alcohol. Some, but the number statistically is 1% of drinkers. The aim which was set out here was hazardous and harmful drinking, which by definition, because it's more than what were called the safe government guidelines, actually does involve increasing hazard. And if you go beyond 50 units per week, you actually are harming. That's medical epidemiological evidence. It may not be harming as much, but it is harming.
Is the answer to Lord Mance's question not that although the proportion of harmful drinkers amongst the affluent is higher, the amount of alcohol that they're drinking per head is much less than in the lowest income quintile?
But that would mean that you define a new class, and the Scottish Parliament, and that's what I mean. As soon as you start saying, well, the aim all along has been that we are attempting to stop the excessive drinking of the harmful drinker in poverty, which I say is 1% of the population. If that is what you have said your aim is, then you might well create a particular series of measures in relation to that. But that has never been said to be the aim. That's been said to be the effect. Now, once they've actually looked at and discovered that harmful and hazardous drinking is associated with affluence. And what then happens is before the court, they say, well, they discount that because they can afford, I don't know, private health insurance so they don't die as quickly.
Yeah. I mean, as you say, that's really introducing a new category of really harmful,
Yes,
or really
absolutely.
hazardous. But there must be, at the basis, I mean, the Lord Order presumably heard quite a bit of evidence on paragraph 59, so don't we have to evaluate that?
Well, no, he didn't. No evidence was heard on this. All that ever happened was that papers were put before the court. It was done in an expedited way, and there was no cross-examination and no affidavit evidence.
Yes, but it's a good forensic point, but the reality in Scotland was that there was a profound concern about the most excessive drinkers. And if I recall the figures, that in the average male drinker in the lowest quintile drinks 30 units per week more than the average male drinker in the higher quintile. And I think the figure for the lowest quintile is 112 units per week. So I see the forensic point, but it seems to me that when one speaks about wanting to stop hazardous and harmful drinkers, the reality of the focus was on the most harmful drinkers. And I'd be astonished if it were otherwise.
Well, but that's not what was said by the Parliament and in the evidence. And we did actually spend some time looking at the evidence before the Parliament.
I've read the policy.
It was a general approach of stopping alcohol consumption generally in Scotland because the average was thought to be too high, something like a litre or more per head, generally higher than in England. That's seen as the norm to chase. So that's why we were introducing a pricing measure, as opposed to a whole variety of targeted area measures, to sociological measures and the like, to deal with the problem of Buckfast Valley. That's the problem one's dealing with. Buckfast, apart from anything else, the tonic wine from the monks of Buckfast Lee, is not caught by minimum unit pricing because it's already above 50 pence per unit, and it also contains caffeine. That's the drink of choice of the NED. And so, if that's the problem, minimum unit pricing is missing it altogether. But in any event, if one looks at page 1054, which is the Sheffield study in April 2016, with its figures in its black box, which produces exactly how many deaths per year will be changed depending on how much you increase the price of alcohol.
Yep.
And I'm not accepting the methodology of any of this, but the fact is, even on its figures, it accepts that the highest level which it expects from MUP, if we see 50 pence MUP, we go down to harmful drinkers in poverty. See that? It's 4 up from the bottom. It's highlighted in orange. The figure it says
Give me the
minus.
page reference again.
Oh, I'm sorry. It's
I'm sorry, I didn't write it down.
1054, my lady.
Thank you.
So this is harmful drinkers in poverty. That's the 1%. And we're told that if you introduce minimum unit pricing under the Sheffield model, that will save 37 of the deaths in that particular category. Now, how they can say it's 37, not 35, 36, there it is. But that's what the model produces. And they accept that income tax.
Yep.
They accept, on the crudest approach to taxation, that the same 37 deaths of harmful drinkers in poverty can be stopped by a rise in excise rates. Now, they say it's at 70%, but that's because it's all on the basis of one is accepting the methodology, which one doesn't, and 2, it's on the crudest possible way of simply raising excise rather than doing any of the other more sophisticated methods. But the principle remains that if it is the 37 drinkers, harmful drinkers in poverty, whose lives you want to save, them specifically, you can do it by excise duty. And the acceptance has always been that excise does not disrupt the market. It's not an obstacle to free movement, as MUP is. And that's the basis on which matters have been proceeding and accepted by the parties. And I mentioned before that the Commission was of the view that excise was the way to go, having heard all the evidence and the claims made in support of this measure as a health measure by the Scottish Government. The Commission's opinion is at page 945. It's in core volume 3 at tab 20.
Page.
945.
Thank you.
So the Commission, first of all, looks at the case law on whether or not the Article 34 is in fact engaged by this measure. Sees that page 946, noting the Dassonville formula and the Van Tiggle case, Tigley, at page 947. Keck and Mittawar. So we go through the whole approach to Article 34. But then at 949, we look at the justification for the measure, it being accepted that it is a measure which requires to be justified because of its distorting effect on the marketplace. But if we go on, and then it examines the evidence which is presented by the Scottish Government. It goes on at page 951, the bottom paragraph. If the goal is for health positive reasons to reduce alcohol consumption via increasing the price of alcoholic beverages, that goal can be achieved by raising alcohol taxation across the board. The price of alcohol would thus increase without causing the market distortions expected to flow from MUP. It is the Commission's view that there is at least one alternative regulatory option which is less restrictive of trade and less distortive of competition.
Yep.
And it repeats that and sets out why it says that they are distortive of competition. But it then goes on to address specifically the Scottish Government's objections, which are set out in its BRIA. We see it at the page 952, the first paragraph headed 1. That is the Commission addressing the Scottish Government's statements in its BRIA at page 856 as to why they were not choosing taxation as an alternative. And the Commission looks at each of those statements and says, weighs them in the balance and finds them wanting. Noting under 1, the Commission would like to note the objective of the measure at issue is to reduce overall drinking, and that will, a minimum price at those levels would affect 73% to 66% of the market. Accordingly, the raising of duties options seems the most suitable because it does achieve that goal without producing adverse effects on competition. And negative effects on the on-trade, because that's another excuse that's put forward, can be reduced by, again, modifying your taxation.
Yeah.
And then they address the Scottish authorities' claim that, well, effectively there might not be pass-through.
Yep.
And they say, well, actually economic evidence doesn't support that as a valid reason. But in any event, as I've said, we have suggested that one possible measure is a banning of, or a requirement that all tax and excise be passed through in terms of the minimum pricing issue, which has been raised and introduced in England.
How easy would that be to do, in the sense that you could adjust the price you're charging and appear to be charging the whole tax?
Well, as I say, my Lord, it's just part of one of the measures. The point is that there is no doubt that requiring pass-through of excise is something which is readily enforceable and creates what may be called a floor price. Now, the issue is, so you can enforce a floor price, which is just excise and VAT, and then the issue is how hard do you push that floor price
you mean
by your excise.
The excise and VAT becomes the floor price and therefore becomes the minimum pricing?
Yes, and then you can vary the excise and VAT accordingly and work out how to get the health aims that you might well achieve. So that actually gets round completely, but the economic realities are, according to the Commission, that in any event that tax rises are ultimately passed through, and that's always been the position which the Court of Justice has said in its experience, because we're talking about a competitive market limited by profit margins, and ultimately tax will be passed through. They then address the issue about the duty of the rate of wine being subject to a band rather than on the actual alcoholic strength of the wine. But the Commission says at page 853, that's paragraph 953, apologies.
Yep.
Directors should provide a degree of discretion, but at the same time reserving minimum rates to allow them to formulate alcohol fiscal policies. In addition, it's to be observed that the regulatory impact assessment claims that in determining their measure by modelling, the modelling does not distinguish between different strengths, but to that effect says the increase of excise duty seems to be the better option to reach the goals.
Yep.
And this is perhaps coming back to the point that was first raised by my Lord Reid. Moreover, it says at 954, there are additional measures which the Scottish Government could adopt. For instance, according to information available, health-related harms are concentrated in particular areas of Scotland. That's the east end of Glasgow and the Rust Belt of Lanarkshire, where I happen to come from. So I'm speaking from bitter experience. There are additional measures they could adopt. Measures which are specifically targeted at these areas are likely to be more effective. So specific targeting at a particular social phenomenon of extreme social deprivation rather than pricing. If you are going to use pricing, pricing's fine if you want to cover the whole population. But if you want to cover the whole population, as they say they do, taxation is the only way forward. So against all that evidence, it comes perhaps as something of a surprise that any court could have reached any contrary conclusion than the one on which I suggest this court must draw. But we know that they did so, but we can identify at least two fundamental errors in each of the Lord Ordinary and of the First Division that showed us why they went wrong. In the first place, the Lord Ordinary went wrong because he applied the wrong test, in that he said that at page 1811, paragraph 80 of his judgment, which is at tab 10 in the second bundle of authorities.
Yep.
He says this at the top of the page: to achieve equivalent prices for the very cheapest products using excise duty, there would also have to be duty rises in many other products. Those products would thus be more expensive than they would have been under minimum pricing. All of the products which would have been unaffected by minimum pricing would be liable to face price increases, some very substantial because of excise duty rises. The average increase in the price of alcohol would have to be significantly greater than under minimum pricing in order to achieve increases in price for the cheapest products of the same order as under minimum pricing. Moderate drinkers and the on-trade would be affected more. The level of protection of health and life imposed would be greater than that thought by the Parliament and the ministers to be appropriate and proportionate. And it was on the basis that it was giving too much protection, more than was wanted, to health and life, that the Lord Ordinary was satisfied that taxation measures would not be a suitable alternative. That particular specific issue was referred to the Court of Justice by the extra division, page 1852.
Yep.
Paragraph 47. And again, this is important because it shows another concession by the respondents. Paragraph 47, page 1852 of the extra division. The referring court does not understand it to be disputed that fiscal measures, particularly excise duty, may enable the United Kingdom to ensure that no alcoholic drink may be sold at a price less than the equivalent of 50 pence per unit of alcohol. Yes, that is correct. That's a simple arithmetical fact. In other words, the desired minimum price may thus be achieved by fiscal means, but there would not be exact equivalence between the benefits modelled as being achieved by minimum pricing and the benefits of an increase in excise duty and other measures. Put shortly, an increase in excise duty may result in wider price increases of alcoholic drinks, and thus a potentially wider reduction in excessive consumption of alcohol and consequent reduction in societal costs of crime, healthcare and the like. But the Scottish Government, the Scottish ministers say that is to bring within the aim of the legislation benefits additional to the narrower aim of particularly benefiting the harmful or hazardous drinker. And this is so, and that's what won before the Lord Ordinary, and it's the point which is then referred by the Inner House for clarification. Can one say that you don't have an alternative, reasonable, a less restrictive alternative because as they say in question 5, the effects of that alternative measure may not be precisely equivalent to the measure, but may bring further additional benefits and respond to a wider general aim. The Court of Justice's response was unequivocal on that. We look at, first of all, the Advocate General's opinion in 1894. Paragraph 150, on the assumption that the rules at issue pursue the targeted objective of hazardous and harmful consumption and at the same time the more general objective of combating alcohol abuse, the fact that the alternative measure is capable of procuring additional advantages by contributing to attainment of the general objective would even constitute a decisive factor that would justify the choice of that measure rather than MUP. So it's a decisive factor that actually brings more benefit. That is upheld as an analysis by the Court of Justice at paragraph 34, page 1902.
Thank you. Yep, thank you.
That's where the twofold objective is confirmed. And then at paragraph 47, page 1904, quote says, as regards the question whether it's possible to refer the adoption of MEP to fiscal measures on the grounds that the objective pursued could not be obtained as effectively by fiscal measures, must be stated the fact that increased taxation of alcoholic drinks entails a generalised increase in the price of the drinks, affecting both drinkers whose consumption of alcohol is moderate and those whose consumption is hazardous or harmful. That does not appear in the light of the twofold objective. So again, that's why it's important, the twofold objective, general population effect and hazardous and harmful. In the light of that, that does not lead to the conclusion that such increased taxation is less effective. On the contrary, as the Advocate General says at point 150, in such circumstances, the fact that increased taxation measures may be capable of procuring additional benefits as compared with MUP by contributing to the achievement of general objectives of combating alcohol misuse, not only cannot constitute a reason to reject a measure, but is in fact a factor to support that measure being preferred.
It's not only additional benefits, is it? It's additional disruption for people who do not need the benefits at all.
Who might they be?
Well,
moderate drinkers.
Moderate drinkers, for example.
Yes, but the evidence which was relied upon is that moderate drinkers also benefit from drinking less. So this is why minimum alcohol pricing, universal pricing measures as something which affects the population as a whole is seen as a good thing, and that's the references to studies by the World Health Organization, which are referenced in the explanatory notes and in the BRIA. So moderate drinkers too are in need of assistance.
Yes, but it isn't the object of the policy.
Yes, it is.
I think it is, Jim. Okay.
That's the whole point about it being the twofold objective. That is the objection.
It's common ground now, the two.
Yes, it is, and it's what the Court of Justice has said in terms that, albeit secondarily, moderate drinkers are a target of this measure to get their consumption reduced as well. So, the Lord Ordinary got it wrong because he applied the wrong test about getting too much benefit. The First Division got it wrong for, among other reasons, the main one being that they redefined what the aim of the measure was, really. It was really about moderate drinkers in poverty, although the Parliament might not have realised it at the time, because it's certainly not part of the justification given. And on their analysis, fiscal measures are a blunderbuss because they hit the rich heavy drinker as well as the moderate drinker of modest means, whereas they say MEP is a rifle which hits the poor and already deprived from drinking as much as the rich get to. It's the poor what gets the blame, and it's the rich what gets the pleasure, to quote an early feminist tract of Mary Lloyd. But this error by the First Division was in any event corrected by the Statement of Facts and Issues, where we are back to the twofold objective of it being a general population measure. That is set out in terms which really cannot be departed from, I hope, at pages 81 and 86 of the Statement of Facts and Issues, paragraphs 1.4 and 2.2. Parties are agreed, all parties are agreed on what the measure is, and agreeing on what the measure is allows this court to apply the proportionality test. So, given the errors of the Lord Ordinary in applying the wrong test, the First Division in considering the wrong aim, those have now been corrected. The first by the Court of Justice decision, the second by the agreement between the parties coming back to define the correct measure. The question remains, is it possible to use fiscal measures to reduce the amount of alcohol consumed by hazardous or harmful drinkers down to at least the level sought by the respondent, and also more generally to reduce the population's consumption of alcohol? Yes. Why not tax? Of course tax. So that was my case, but the second respondent has put in new questions which were not agreed by either of the other parties, which we say don't arise from the grounds of appeal, didn't arise in any cross-appeal, and really are hypothetical questions in any event. I was hoping to reserve any response I might have to that in the hour which I had banked, if necessary, my Lord. But if that's acceptable, then I would stop now, having taken up the 3 hours which I'd said I would.
Thank you very much indeed, Mr. O'Neill. Thank you. Ms. Ross?
My Lord, my Lady, my Lords, I have nothing to add to those comments.
Very much. Lord Advocate.
My Lady, my Lords, I invite the Court to refuse this appeal. I will be inviting the Court to attend closely to the aim of this measure and to take the view that the courts below were correct to conclude that fiscal measures would not be as effective as the measure before this Court in achieving that aim. And in developing that submission, I'm going in my first chapter to look at the policy which underpins the measure, and then in my second chapter to address the question that was posed at the outset, why not tax? And in my first chapter, I'll make submissions in support of 6 propositions.
Yeah.
The first is that the measure represents a targeted response to a serious health problem in Scotland, which is caused by excessive alcohol consumption, and in particular by the availability of alcohol which is cheap relative to its strength.
Yep.
Secondly, the measure seeks to strike a balance, targeting the consumption in particular of hazardous and harmful drinkers who are particularly at risk of alcohol-related harm, whilst not imposing disproportionate costs on moderate drinkers. Thirdly, it is a measure which is easy to understand, simple to apply, and straightforward to enforce. Fourthly, there is a strong evidence base for concluding that it will be an effective intervention.
I don't think you need to go. That's not disputed, is it?
It's not in dispute, my Lord. That's correct. But it is important, perhaps, just to make the point that there is a strong evidence base for the effectiveness of this intervention. I recognise, and this is my 5th proposition, that there remain uncertainties, particularly in relation to the response of the market. And the short point there is that this has been that has been recognised in the fact that this is a time-limited measure which will expire after 6 years, if not then renewed, with an obligation on the Scottish Government to evaluate the effects and to review them 5 years after.
Yep.
And the sixth proposition is that the measures are underpinned by a significant piece of policy analysis reflected in the policy memorandum, the explanatory notes, and the business and regulatory impact assessment. If I might make some submissions to elaborate on my first proposition, with the particular reference to the business regulatory and impact assessment, which the court has at tab 19 in volume 3.
Page.
And I'm going to start by looking at, I'm going to start at page 0817.
Thank you. Yep.
It's not the front of the front of the document starts at 0811.
Thank you.
But at 0817 through to 0819, the question why minimum pricing is addressed. And in particular at 10, Scotland's minimum pricing policy aims to reduce alcohol consumption and in particular targets a reduction in consumption of alcohol which is cheap relative to its strength. Minimum pricing achieves this aim because it is both a whole population approach and a targeted intervention. It applies to the whole population, but hazardous and harmful drinkers are likely to be affected more than moderate drinkers in terms of the amount they drink, how much they spend, how much they benefit from reductions in harm. Hazardous and harmful drinkers drink proportionately more alcohol, which is cheaper relative to its strength. The measure is able to target cheaper alcohol relative to its strength because the minimum price is determined by and is directly proportionate to the number of units of pure alcohol in an alcoholic product. Furthermore, it is not possible to absorb the effect of minimum pricing by selling a product below its minimum price. The level of the minimum price per unit can be varied proportionate to the reduction in alcohol-related harms that the measure is intended to achieve based on the latest evidence available. Minimum pricing per unit is simple to understand, measure, and enforce. And then there's a point made at 12 about the non-discriminatory nature. And then at 13, the policy objective of protecting and improving public health would not be achieved through increasing alcohol duty and taxation, and a number of reasons are set out, and I'll look in more detail at that in my second chapter.
Yeah.
And at 14, minimum unit pricing has the advantage over taxation in that moderate drinkers who disproportionately come from low-income groups will be largely or completely unaffected by virtue of the fact they drink very little and do not tend to purchase the type of products that will be affected by minimum pricing. Moderate drinkers are estimated to pay a relatively small additional amount per year, around £8 for a 50p per unit minimum price. Of course, this must be seen in the context of the significant savings to health, criminal justice and productivity costs brought about by minimum unit pricing. The greatest health benefits are estimated to be seen amongst hazardous and harmful drinkers as they disproportionately consume cheap alcohol. Minimum pricing, therefore, effectively targets those individuals who will benefit most from a reduction in consumption. That's a summary which is based on detailed analysis, which the court will see in parts 2 and 4 of the BRIA. But I just note in passing that the court can see there an analysis founded, I say, on evidence, which addresses appropriateness and necessity. And so if I could then take some key propositions which underpin the policy, and perhaps, if I may, simply give the court references to where those may be found. The first is that Scotland has a very high per capita consumption of alcohol. And that's at 214 to 216, MS 0829 to 0830. a per capita consumption which is reported to be almost a quarter higher than that in England and Wales. Secondly, Scotland has a significant alcohol-related health problem. That's elaborated at 220 to 223, MS 0832 to 0834. And at 220, there are figures for the mortality rates, the alcohol-related mortality rates, and alcohol-related hospital discharge rates in Scotland, which disclose that the alcohol-related mortality rates for men in Scotland were double those for men in England and Wales. And there is a similar pattern for women. The third point is that the greatest harm is experienced by those who live in the most deprived areas. And that's at 229, MS 0836. And there are updated figures recorded in the Inner House decision at paragraph 127, MS 0825.
Sorry, what was that MS again, please?
MS 0285, paragraph 127 of the Inner House.
Yes, thank you very much.
Where we're told that in alcohol-related mortality rates in the lowest quintile are 8 times that in the most affluent quintile. Alcohol-related hospital stays are 7.7 times. The fourth point is that, unsurprisingly, alcohol-related harm is strongly related to consumption. Hazardous and harmful drinkers are at the greatest risk of harm. Hazardous and harmful drinkers in poverty have the greatest incidence of harm. And I've just given an example in the figures for mortality and hospital admission rates. There are, of course, complex reasons for that, but one factor is that hazardous and harmful drinkers in poverty drink more alcohol on average than hazardous and harmful drinkers in other income groups. And that's noted at paragraph 5.24, MS 0866. And there are updated figures in the Inner House decision at paragraph 127, MS 0285. And the court can see the point in graphic form in the Sheffield study at MS 1034 at figure 4.8. There is perhaps a point I should make. It's most easily seen from my case where there is reference to the sourcing for it. It's at 4.42, MS 0187.
0187.
0187, 4.42, where it's observed that there is a particular problem in Scotland with cheap vodka. Of the additional volume of alcohol sold in Scotland compared to England and Wales, 71% is attributable to spirits sold at under 50 pence a unit. And NHS Health Scotland has concluded this pattern was largely driven by vodka, with 2.4 times more vodka being sold off-trade at below 50 pence a unit in Scotland than in England and Wales.
Right.
And I make that point perhaps to deal with.
So what is the relevance of your case 4.40? That's about niche manufacturing.
So it was 4.42, my lord. I do apologise. And the relevance of that and data I mentioned a moment ago is to make the point that the problem in Scotland is not the same as the problem in England and Wales. And that it's therefore important to, when looking at studies and statistics, to look at studies and statistics, in particular the Sheffield April 2016 study, which is based on the data applicable in Scotland, and not data such as the February 2016 study, which is derived either from English statistics or from whole UK statistics. And the other reason I mention the point about cheap vodka is that Mr. O'Neill drew the court's attention in the English study to a suggestion that a 0.22 excise duty on volumetric tax would reduce the level of drinking. And I simply make the point that the current excise duty on spirits is 28.7 pence. Yes. Yes, so that option would be a reduction in the excise duty on the cheap vodka, which is the particular problem identified in the material I've described. My lords and my lady, there are two features of the alcohol consumption of hazardous and harmful drinkers which are worth mentioning. The first is that they drink alcohol which is cheap relative to its strength. And that's supported by evidence at the BRIA, paragraph 5.11, MS 0862, and the Sheffield study at MS 1028. By contrast, moderate drinkers not only drink less, but do not tend to purchase the products which would be affected by minimum unit pricing. And the court can see that in graphic form at figure 4.6 of the Sheffield study at MS 1030. The second feature of the consumption of hazardous and harmful drinkers, which I should mention, is the evidence that they will trade down to the product which gives the most alcohol for the lowest price. And there was evidence on that matter given to the Sport and Health Committee of the Scottish Parliament by a number of experts at MS 5270. The court will find there proceedings of that committee. So faced with these particular features and the particular health problem, minimum unit pricing is a direct response. First of all, it directly affects the retail price to the consumer. Secondly, it directly addresses the problem caused by the availability of alcohol which is cheap relative to its strength. And thirdly, it imposes a floor price which prevents trading down. It therefore effectively targets those who will benefit most from a reduction in consumption, namely hazardous and harmful drinkers. That's said at the BRIA, para 15, MS 0819. The greatest health benefits are likely to be felt by hazardous and harmful drinkers in poverty, both because they suffer the greatest alcohol-related harm. And also because those on low incomes are likely to be more responsive to minimum pricing. And if I could take the court to the Sheffield study at MS 1035, it's in volume 4. Tab 23.
Which page we're looking at?
It's perhaps best seen at page 1037.
Yes.
There's a table which estimates the impact of minimum unit pricing on consumption by drinker and poverty group. And if the court goes to the absolute change per drinker per year in units,
Yep.
the 50p minimum unit pricing, and reads across,
Yep.
the court can see the estimated impact on different cohorts of drinkers, particularly hazardous and harmful drinkers, and they can see in particular the impact on those in poverty. And that feeds through to health outcomes in the figures at 1049 and 1050. And in particular, the relative change in deaths. I think it's perhaps the text at 1048 to 1049 tells us the health gains are greatest in hazardous and particularly harmful drinkers in poverty, with an estimated 119 deaths per year averted per 100,000 harmful drinkers in poverty, compared to 16 deaths averted per 100,000 harmful drinkers not in poverty. Now, to draw attention to that is not to alter the aim, which is to tackle the consumption of hazardous and harmful drinkers. It is to recognize that the greatest health benefits will be secured by the reduction secured in the cohort of hazardous and harmful drinkers in poverty. And it's perhaps important to make the point that the aim is not to reduce consumption for the sake of it, but to reduce alcohol-related harm. And that's precisely why the aim is expressed primarily, or it's expressed in terms of targeting hazardous and harmful drinkers, because they are the drinkers who are most at risk of alcohol-related harm. And I might just make this point at this stage, that against that background, my learned friend's criticisms of the inner house, the passages in the inner house, are, I would submit, unobjectionable. They reflect the fact that in targeting the consumption of hazardous and harmful drinkers, it is amongst hazardous and harmful drinkers in poverty that the greatest health benefits will be felt. I should perhaps just read the aim as it's been agreed. It's in the Statement of Facts and Issues at MS 0081. The minimum unit pricing legislation pursues a twofold objective, that of reducing in a targeted way both the consumption of alcohol by consumers whose consumption is hazardous or harmful, and also generally the population's consumption of alcohol. And it's important to notice it's reducing in a targeted way. Those two cohorts. The reason why the aim extends beyond hazardous or harmful drinkers is that moderate drinkers do drink some alcohol below 50 pence minimum unit price. So there will be an effect on the consumption of moderate drinkers. The aim, the measure will have effects that are not confined to the cohort of hazardous and harmful drinkers, although that is the primary target.
Your submission is that the collateral consequences of an increase in excise on moderate drinkers, although to some extent beneficial, will be vastly disproportionate to the benefit in question.
Indeed, my Lord. And that really takes me to my second proposition, which is that this legislation seeks to strike our balance. The Scottish Government recognises that many people in Scotland have, as it's put in the documentation, a balanced, positive and enjoyable relationship with alcohol. That's at MS 0856 of the BRIA, the second bullet point. And if the court chooses to look at the Scottish Government's strategic framework, changing Scotland's relationship with alcohol, which is at MS 7891.
MS what?
At MS 7891, the court will see at paragraphs 2, 7, 10 and 15 comments to the same effect. Part of the overall objective of the strategy is to promote cultural change. And it is a positive advantage of the measure that the court has before it that it does not impose those disproportionate costs on products that are enjoyed by moderate drinkers.
Right.
The proposition is that this is a balanced measure which seeks to reduce in a targeted way consumption which particularly gives rise to alcohol-related harm, but which does not have disproportionate effects on moderate drinkers. And the court can see that at the BRIA paragraph 5.1 MS 0860. Perhaps I could draw the court's attention again to the Sheffield study, figure 4.6 at MS 1030.
Page number again, please.
MS 1030.
1030.
Figure 4.6. Which shows the current mean consumption in the different cohorts, which shows that there is moderate drinkers consume some alcohol below the 50p per unit figure, albeit not in anything like the same proportions as harmful drinkers. Perhaps the point can be made this way. From a purely health point of view, the higher the price, the better.
Yeah.
This measure seeks to strike a balance. And there's perhaps another point to be made about balance, which is that this measure is seen as complementary to the effect that excise duty has on consumption. This is not an either-or. The key feature of minimum unit pricing as a measure complementary to excise duty is that it focuses on an issue which cannot be specifically addressed, or at least certainly cannot be readily specifically addressed through excise duty, namely the harm to human health which is caused by the excessive consumption of alcohol which is cheap relative to its strength. Might just make this point. When the court comes to look at the Lord Ordinary's opinion, the court will see that he carefully and, in my submission, accurately identified the nature of the balance that this measure seeks to strike. And the court will also see that in the Inner House at paragraph 185, MS 0311. And it will be important when the court comes to my submission on fiscal measures to appreciate that minimum unit pricing is a specific measure targeted, as the agreed aim states, complementary to excise duty, and that its targeted nature is intrinsic to what it seeks to achieve. My third proposition is that the measure is easy to understand, simple to apply, and straightforward to enforce. This is important for two reasons. First of all, because minimum unit price sets a retail price floor and thereby prevents trading down. Measures that would not reliably set a price floor would be less effective in achieving the targeted aim. And secondly, because there is evidence that retailers may discount alcohol. That's described in the BRIA at MS 0856. In a bullet point, the last bullet point on that page. A measure such as minimum unit pricing, which is not susceptible to discounting and cost absorption, and which does not permit trading down, will prima facie be a more effective measure than measures which are susceptible to such activities. So in the context of the aim of reducing consumption, in particular amongst hazardous and harmful drinkers, it is a benefit of the measure that it addresses directly the retail price to the consumer.
Is it the need to ascertain the producer's cost in order to set a floor which takes account of cost that you have in mind, or is it something else?
That's part of the second point, my lord, because excise duties imposed when the product is released for consumption simply form one component in the cost, which is reflected in the price. Any attempt through excise duties to achieve a reliable price floor at the retail point of retail sale would accordingly require flanking measures to address sale below cost. And that immediately gets one into difficult questions about policing cost. And the appellants recognise that. They postulate a rule that the product may not be sold at a price lower than duty plus VAT. But my point is to step back and say that itself recognises that a measure that is based on excise duty, if it's to achieve the beneficial effects that I've just described require flanking measures. The fourth point is the one that, as my Lord Hodge has observed, it is not disputed that there is a strong basis for concluding that the measure will be effective in achieving its aim and thereby securing benefits to the health of people in Scotland. And the analysis is set out in the BRIA. The court can see it's based on evidence, it's based on expert opinion, it's based on experience in the jurisdictions. And the anticipated health benefits have been estimated through modelling, most particularly now through the Sheffield 2016 study. My fifth proposition was to acknowledge that there are nonetheless areas of uncertainty. And that's precisely why these measures are time limited, why the government is required to evaluate them after 5 years, and why the legislation will expire after 6 years if not renewed. And I'll perhaps just make these points about the uncertainties. The first is that the government consulted widely on the measure, including with the industry, and specifically asked about the effects of the measure. The court could see that at paragraph 3.15 at MS 0854. And the court can then see a number of points at which the evidence did not allow conclusions to be drawn at paragraphs 5.2, 5.38, 5.49, 5.101, and 5.114. And indeed, the report that the appellants produced from Yarrow and Decker acknowledged the uncertainties, particularly at paragraph 96, MS 1132. One of the significant sources of uncertainty being the point that minimum unit pricing may in fact incentivize retailers to purchase low-cost products because of the markup. The short point that I make at this stage is that the government is not obliged to seek to resolve every area of uncertainty. And as I say, in this case, recognizing the areas of uncertainty, this is a time-limited measure. And the final proposition in this part of the submission is that the measure is underpinned by the analysis disclosed in the policy memorandum, the explanatory notes, and the business and regulatory impact assessment at tabs 17, 18, and 19 of volume 3. Supported by reference to evidence, following a substantial process of consultation, and which disclose, as I'll show in a moment, a consideration of alternative approaches and a reasoned rejection of those approaches. I started this passage by looking at MS 0817 to 0819, which explains in summary why this is an appropriate and necessary measure to address health harms caused by excessive alcohol consumption document. Perhaps to make the submission at this point, I say that what the court has there, in the BRIA particularly, is an analysis of the appropriateness and proportionality of the measure, supported by reference to specific evidence, which is referred to in it. And I make that point although my learned friend hasn't developed the point, in response to his criticism or his statement that the government doesn't, has not complied with the evidential requirements of the law, and has in that document an analysis of appropriateness and proportionality, supported by specific evidence, and which has since been supplemented by additional work, notably the Sheffield April 2016 study, and a body of additional information which was available to the courts below, and from which they were entitled, I say, to draw conclusions.
You just identify the material again, Sheffield?
Well, it's the Sheffield April 2016 study, and it's fair to say a body of other material. Yes. Yes. I don't, right at this moment, have a long list of the material to give to my lord, but...
What about the criticism, effectively, that this looks at one side of the picture? It says you can address the problem this way, but it's addressing, in terms of overall drinking, a relatively small percentage of over-committed drinkers, and it's doing so by a method which certainly affects, as common ground, the market and interstate trade, whereas there's no real analysis, is there, of the possibility of it being done by an uplift in excise duty, maybe one which is nuanced in the way that Mr. O'Neill was suggesting, but I think has been put somewhere as a 22% uplift across all drinkers, which would certainly have some potential general benefit in reducing consumption overall.
Well, I suppose the first point to make, my lord, is, and the next chapter I'm coming on to, is that the BRIA does address fiscal alternatives, and the court will see at MS 0855 through to 0859 a discussion of alternatives. I'm about to come to that.
Right.
But the other point, my lord, on the question of the market, is that the BRIA also, in the Part 5, looks at costs and benefits, and it seeks to address the impact on trade. For example, at 5.72, it tells us that the modelling estimate...
What's the page?
Sorry, I do both. MS 0882.
0882, thank you.
That the modelling estimates a small decrease in wine sold. A small decrease in wine sold as... Sorry, my lord. A small decrease in wine sold as off sales and a marginal increase in on sales. Using similar methodology, the decrease in off sales of wine, this is all wine, not just EU wine, is estimated to be around 3%. And assessments of the impact on the market in other alcohol categories is identified in the preceding paragraphs. So it's quite wrong to say that the impact on the market, including the market in wine, was not addressed in this document.
I think the later materials that you spoke of included material indicating where the various EU producers who might be affected were.
Indeed.
That's one of the later documents to come in.
Indeed, my Lord. It's actually very conveniently set out in the appellant's case
Yes.
at paragraph 4.59.
Yes.
And it's perhaps just worth looking at that. MS 0139. Yes. All right. But my learned friend tells me the figures are wrong. I'll get the correct document for the morning. But I might just make the point that those
The
figures...
figures in his case are wrong.
Sorry?
The figures in his case are wrong.
Indeed. I hadn't picked that up, I have to confess. But
Right, well,
I'll make sure I've got the right figures for the court tomorrow. And I might just make the point that these are figures that derive from a MESAS document. MESAS being monitoring and evaluating Scotland's alcohol strategy. I just make the point that the commitment to evaluation of this measure at the end of 5 years takes place in the context of a continuing monitoring and evaluation of the country's alcohol strategy. Perhaps I could just in relation to the point that the Lord Mance put to me just a moment ago, Just invite the court to look at, I mentioned it earlier, at figure 4.6 in the Sheffield study at MS 1030. Because what that does illustrate in my submission is the extent to which it is cheap alcohol is disproportionately consumed, purchased, and one assumes consumed by hazardous and harmful drinkers, and the relatively small proportion that it forms of the moderate drinkers' consumption.
well, that was paragraph 4.3.
It's figure 4.6 at MS 1030.
1030, thank you.
The 1030.
Yes.
That's an MS.
Yes, it is.
No.
1030. Figure 4.6. And we looked
Yeah,
at
we
before.
looked at this before.
Yes. It's really just to make the point, meet the point that my Lord Mance put to me, which is, and it's to illustrate that this is a measure targeted on alcohol which is cheap relative to strength, which is alcohol disproportionately consumed by the hazardous and harmful drinker. And it's accepted there will be some impact on the moderate drinker, which is why the aim is expressed in the twofold way that it is. But the impact
The
on...
mean price paid on that figure is quite striking.
Indeed, Lord. Yes. Indeed, Lord. So perhaps I could go to the question of why not tax. And again, if I might do that by looking at the BRIA. And draw the court's attention to 4.3 at MS 0855.
Yep.
The Scottish Government has noted the suggestion that the policy objective of protecting and improving public health by reducing alcohol consumption could in theory be achieved through increasing alcohol duty and taxation, and is often cited as a less intrusive method of achieving public health objectives. However, each case needs to be considered separately. And the Scottish Government does not consider the option of taxation on its own, with the current duty regime, to be an effective alternative approach for the reasons set out below. And the on its own it makes the point I made earlier, that this is complementary to excise duty, and it's the targeted nature of it which makes it an effective measure. It is interesting to note the UK government is also pursuing a minimum pricing approach in order to tackle the cheap price of alcohol in the off-trade. So, and then there are a set of bullet points which look at tax. There is evidence that across-the-board tax increases do not have a targeted effect on the consumption of alcohol of those most at risk of alcohol-related harm. And there's a reference to a study in the footnote which is said to show that price increases targeted at the lowest cost brand would produce a greater reduction in sales than across-the-board price increases. And then the BRIA goes on to say, this is because harmful and hazardous drinkers consume a disproportionate amount of cheaper products. A minimum price is a measure that is targeted at products priced cheaply relative to their strength. A straightforward increase in existing duty would impact on high-priced products as well as cheap ones, and so would have a proportionately greater effect on moderate drinkers than a minimum price. When they are passed on, taxes affect all drinkers, while minimum pricing only impacts on consumers who currently purchase alcohol below the minimum unit price. Minimum pricing recognises that many people in Scotland have a balanced, positive and enjoyable relationship with alcohol. Recent sales data estimates that about 2/3 of all pure alcohol sold in Scotland in 2010 was sold through the off-trade. The average price of a unit of alcohol sold through the off-trade in Scotland was 45p a unit, and through the on-trade 134p a unit. Minimum pricing and duty increases apply equally to both the on and the off-trade. However, given that more alcohol is consumed in the off-trade than the on-trade, and the price of a unit is far cheaper in the off-trade, a pricing measure that predominantly affects the off-trade is likely to be more effective at tackling alcohol harms. Increases in tax of alcohol will not necessarily result in a proportionate or indeed any increase in the price of alcohol, as alcohol tax and duty increases are not always reflected in the price the consumer pays. For example, the Competition Commission's paper on pricing practices noted that 10 grocery retailers, 9 of whom operate across Scotland, engage in below-cost selling to varying extents. The Competition Commission further notes that for most grocery retailers, the majority of below-cost sales relates to 2 or 3 product groups, alcohol being one of them. This suggests that tax increases are sometimes absorbed by the retailer, absorbed by the producer, or offset against other products. This means the price to the consumer can remain static or reduce, resulting in no reduction in consumption and no reduction in harm. To the extent that prices are offset, customers are paying more for other groceries to subsidise alcohol consumption. Absorption also means that the level of tax needed to achieve the same reduction in harms as a minimum price per unit of 50p is difficult to ascertain. For a tax system to result in increases in the price of low-priced products, but not in the price of high-priced products, the rate of tax would have to be higher for low-priced products. And I should say there's an assumption built in there that that would be legally possible. A tax increase based on price would disproportionately affect the market because low-priced, relatively low-strength products would increase as much of that as that of low-priced, relatively high-strength products. And depending on the level that the tax is set at, only the price of some alcohol products sold cheaply relative to their strength may increase. And one might also say it might have a curious effect on the pricing decisions of producers. A scheme of tax that was levied on a unit of alcohol and so treated products of the same strength in the same way would not comply with the current system of excise duty required by EU law. EU directives limit the ability to align duty with alcoholic content. And then there's a reference to the directives. These directives mean a rate of duty for wine needs to be based on the range of the alcoholic strength of each particular wine, rather than on the actual alcoholic strength of the wine, and so prevent there being a scheme of taxation levied on a unit of alcohol. For example, wines of strength 8.5 to 15% would attract the same duty rate. And then the BRIA goes on to say, even if it was possible to formulate a scheme of taxation proportionate to the number of units of alcohol in a product, it would remain possible for retailers, particularly large supermarket chains, to absorb this tax by loss leading on alcohol and putting up the price of other products. The wholesale cost of individual alcohol products varies from time to time, and particularly in the context of retailers carrying different lines from individual suppliers, is susceptible to manipulation. Absorption could not be prevented by prohibiting sales below cost plus tax, because costs would always be susceptible to manipulation. A prohibition on absorption would in fact only prevent absorption of tax. In order to have the same effect as a minimum price per unit, tax would have to be set at the same level. This would result in a tax rate across all alcohol products at a considerably higher rate of tax than is currently in place. And then a minimum price per unit has the advantage of certainty. It's not open to absorption. It does not encourage cross-subsidization between different products and product groups. Due to its simplicity, it is easier to understand, measure, and enforce. And then there's a point about revenue. And then on the next page, the BRIA goes on to address the option of preventing the sale of alcohol below the price of duty and VAT, and states that the Scottish Government has never considered this to be an effective alternative approach to minimum pricing for a number of reasons. Based on current VAT and duty rates, it would create a minimum price which would be so low as to have little or no effect on public health, and so would not achieve the Scottish Government's objective of reducing alcohol-related harm. Since taxes are not fixed by reference to their anticipated effects on health, and because taxes are not imposed uniformly, this approach may have a disproportionate effect on some products and not others, and then that's illustrated. And then at the bottom of the page, the minimum unit price option is looked at. Yes. Yes, it's worth perhaps inviting the court also to read 4.5, which notes the UK government's impact assessment on its proposal, which identifies the anticipated impact of that measure. So, my lords and my lady, I say the BRIA has looked at the question of achieving the aim through an increase in tax. The government has concluded that the option of tax on its own with the current duty regime is not an effective alternative approach for the reasons that are set out. And in my submission, these are cogent reasons in the context of the particular targeted nature of the aim, focused on the cohort of consumers who are most at risk of alcohol-related harm. These are considerations which justify that conclusion. I might just observe that at 2.33 to 2.34,
Page.
MS 0837 to 8.
Yep. Yes.
There's reference to a report which is recorded as concluding, having looked at various options, that the strong association between alcohol policies and alcohol harms provides a compelling reason for considering a range of pricing policies for inclusion into a policy mix to tackle the problem. And what the Scottish Government seeks to do is to use this particular pricing policy as
some of the points in paragraph 234 repeated, picked up in the bullet points.
They are, my Lord, essentially. Yes. Now, the Court's aware that 2 exercises have been undertaken since, which, yes, I'll just perhaps make this point, and then if the Court would allow me to close for the day, just to make the point that 2 exercises have been undertaken which seek to estimate the kind of tax increases that would be necessary in order to generate savings in alcohol-related mortality and equivalent to 50p minimum unit pricing. And that's, first of all, the Sheffield April 2016 study, which the Court's already seen. And the other is a table, Table 6, at MS 0185, which is an exercise which really seeks to do what the appellants describe at paragraph 4.27 of their case.
Could I have the reference again? I'm so sorry.
It's at MS 0185. It's reproduced in my case.
Seeks to do what appellants say in paragraph 1.
What it's seeking to do is essentially try and identify what the effect would be of trying to replicate a 50p minimum unit price through the existing tax and duty regime.
And that was appellant's paragraph, something you mentioned. No, it doesn't matter, don't worry.
Yes, it's a table that's at, in my case, at MS 0185, which...
Yep.
Is that an agreed table? How is it constructed? I don't think
Mr. O'Neill's shaking
didn't
his
think it would
head.
be.
Shaking his head. Well, I can perhaps come back to these points in the morning and seek to draw some conclusions from them.
That's a convenient moment.
It would be, my Lord.
Thank you very much indeed. We'll resume again at 10:30 tomorrow morning.
Thank you.
Thank you. Court is adjourned.